As we discussed in part 1 of this series, in the REGAL Act, Congress directed each of the federal banking agencies to create an intra-agency appeals process. So today we're going to talk about the OCC's intra-agency appeals process. And in particular, I want to talk about what OCC determinations are appealable, the procedure that the OCC has created for filing the appeals, some special procedures that apply to certain kinds of determinations, and what you should do if you're thinking about challenging an OCC determination. So the first thing that any financial institution needs to think about if considering whether or not to challenge an OCC determination using the intra-agency appeals process is whether or not the OCC's determination is even appealable. Not everyone is, but the OCC has identified a variety of different determinations that are appealable, but their list isn't exhaustive. It includes the OCC's determinations of examination ratings, the adequacy of allowance for loan and lease loss methodology, individual loan ratings, violations of law, shared national credit decisions, fair lending related decisions, licensing decisions, and any material supervisory determinations such as matters requiring attention, compliance with enforcement actions, or other conclusions in a report of examination. The OCC has identified some of its determinations that it believes are not appealable under its own intra-agency appeals process. So that includes appointment of receivers and conservators, preliminary examination conclusions that are communicated before a final report of examination, as for example, communications that are provided orally at an exit meeting. And in addition, the OCC doesn't want banks to try to circumvent the normal procedures that apply to enforcement actions. So accordingly, the OCC doesn't allow institutions to appeal the seeking of an issuance of a cease and desist order, or if the OCC is seeking a civil money penalty, when it takes prompt corrective action under Section 38 of the FDIA, when it issues a safety and soundness order under Section 39 of the FDIA, or when it commences a formal investigation under 12 U.S.C. Section 1818. In addition, the OCC has taken the position that decisions to disapprove directors and senior executive officers can't be challenged through the intra-agency appeals process. And finally, for the same reason that the OCC doesn't want a bank to try to circumvent the normal procedures, they have taken the position that banks can't appeal any other OCC decisions that are subject to judicial review other than those that are identified as appealable matters in the OCC's guidance. Unlike other federal banking agencies that have created an intra-agency appeals process, the OCC actually lets financial institutions choose between two different procedures. The first option is a two-tier approach. Initially, the bank files the appeal with the deputy comptroller, and then if the bank doesn't win, it can follow a second-tier appeal to the OCC's ombudsman. The second option is for the bank to immediately file the appeal directly with the OCC's ombudsman. However, if the deputy comptroller participated in making the decision that's under review or reports to the OCC official that made the decision, then the deputy comptroller always transfers the appeal to the ombudsman. And that effectively changes the two-tier approach into a one-tier approach. The reason the OCC's done that is to comply with the requirement that is in the REGAL Act that the intra-agency appeals process be independent of the original agency determination process. The procedure for the initial appeal is the same whether the appeal is filed with the deputy comptroller or with the ombudsman. The deadline is within 60 days of the bank receiving the final written decision that is being appealed. And the content of the appeal is there needs to be a written description of the matter in dispute. There needs to be a written articulation of the reasons for the disagreement with the OCC's determination. And then finally, the bank has to include the board of directors' approval of the appeal. Generally, the OCC, after it receives the appeal, will issue a decision within 45 days. If the OCC's initial appeal decision was made by the deputy comptroller rather than the ombudsman, and a financial institution doesn't like that decision, then it can appeal the decision from the deputy comptroller to the ombudsman. It has 15 days to file that appeal, and then the OCC ombudsman will generally issue the decision within 45 days of accepting the appeal. For certain determinations, the OCC has created special procedures for appeal. And one example is where the OCC created a special procedure for appealing shared national credit, or SNC, decisions. The OCC requires the bank to notify the examiner in charge if it disagrees with an SNC decision before it files a formal appeal. And only if the examiner charge doesn't change its decision, the bank then has 14 days to file an appeal with the Deputy Comptroller for Large Bank Supervision. If the bank disagrees with the decision by that Deputy Comptroller, it can file a second-tier appeal within 30 days of receiving that decision. The OCC has also created special procedures for appealing determinations on measures related to fair lending, where a bank receives written notice of a determination from a senior Deputy Comptroller that there's reason to believe discrimination has occurred that warrants referral to the Department of Justice or the Department of Housing and Urban Development, then the bank can appeal to the Ombudsman within 15 days. The OCC has also created a special procedure for appealing determinations on certain disapprovals of directors and senior executive officers. So OCC disapprovals of directors and senior executive officers of certain institutions, such as those that are in troubled condition, are not directly appealable to the Ombudsman. Rather, they're appealable directly to the Comptroller within 15 days of receipt of the disapproval letter. So if the OCC made a determination that applies to your bank and you don't like it and you're thinking about challenging it using the intra-agency appeals process, what should you do? Well, first you should consider watching the first video in this series, where I talk about some of the strategic implications of the intra-agency appeals process generally. Next, because this is a legal process, you really want to consult with your legal counsel, and that will involve asking your counsel a number of different questions. You want to ask them about whether the type of determination in question is even appealable. You want to have your counsel confirm that the procedure and the deadlines that we discussed in the video today haven't changed since this video was recorded. And you want to talk about the strategic issues that are related to whether you pursue the one-tier approach or the two-tier approach that we discussed earlier. When you're initially consulting with your legal counsel about whether or not to file an intra-agency appeal, you should consider whether at the same time you want to apply to the OCC for permission to disclose confidential supervisory information to your counsel. And that's because it may be important for your counsel to have access to certain documents in order to prepare the appeal that are protected by the laws that govern confidential supervisory information. And you should consider whether at the same time that you request this authorization to share the documents, that you request an extension of the deadline for filing your appeal, because while you're waiting for that authorization, your lawyer won't have access to those critical documents. You also want to simultaneously reach out to your board, and that's because approval from the board of directors has to be included when your appeal is filed. So because this process is fast-moving and there's a lot of different moving parts, you should strongly consider hiring a law firm that is experienced in handling intra-agency appeals.